chair will call case number 007664, 14 Arrow Street. Anyone here wants to be heard in this matter? Mr. Sousa.
Good evening, Mr. Chairman, members of the board.
You must have a cold.
I do. I'll stay
far away.
at a decent distance.
Before you do your presentation, let me,
Yes.
for the benefit of the board members, for some context of what we're going to be doing on this case tonight, because I've been in under numerous discussions with the city's legal department about this, and I don't think the other members have the benefit of all that. Back in December, I guess it was December 7th, was that?
November 19th, I believe.
Was that early?
Yes.
November 19th. We had two applications before us with regard to 14 Arrow Street. One was an application for a special permit under our ordinance, applying Section 6409 of the Spectrum Act. And the second one was relief, direct relief, if you will, under 60409 of the Spectrum Act. At that, so one or the other, I guess you would say. At that meeting, Mr. Sousa requested that we withdrawal of the application for the special permit under our zoning ordinance, and we voted to accept that. Then we proceeded to discuss and decide the other case, on the one that's directly, if you will, under 6409. Subsequent to that action, the city's legal department advised the board and Mr. Sousa that the only way they can get relief, his client can obtain relief for the additional antenna, would be to file a special permit application under our ordinance, the zoning ordinance. Of course, that had been, he had done that, but had been withdrawn, and under section 10.51 of our ordinance, a withdrawal is treated as a denial of an application, and no new application can come before us for 2 years unless there's a substantial modification to what was originally proposed. So that left everybody in sort of a limbo. Mr. Sousa could take the city to court and pursue on the grounds that it's wrong that we have to have a special permit under our ordinance, that 6409 permits direct special permits, or he's going to wait his client's got to wait 2 years. It was determined that the decision we made to accept his request for withdrawal of his special permit application under the ordinance was not final. It's not become final because the written decision had not been filed with the city clerk's office. So tonight, Mr. Sousa is before us asking us to reconsider, which our legal department has advised us we have a right to do, to reconsider his request to withdraw his application under our zoning ordinance. Should we grant that, should we agree to reconsider, then I think you will withdraw your request for the withdrawal of that application? And then therefore we'll consider the special permit under our ordinance directly.
I believe that's the motion, is to essentially open up that special permit application.
Yeah, we got to reopen. We get rid of the withdrawal first. And that's what the reconsideration is about.
That's right, exactly, and reconsider the special permit application.
Okay.
And I didn't mean to cut you off,
No.
Mr. Chairman, and I agree with the way you stated the facts and the position of the law department. That's been consistent with my discussions with Attorney Kawai, the law department. I would say that Section 6409 is fairly new legislation, and it was fairly thin when it was passed. It was further expounded on by the FCC order, which was fairly lengthy, included some additional details as to how municipalities should treat 6409 eligible facilities requests. And it's a little bit unclear as to whether or not a municipality is required, or whether or not a petitioner is required to obtain a special permit or simply a building permit. Many municipalities in Massachusetts have actually simply received the eligible facilities request, approved them, and issued building permits. A number of them have done so, and not required the petitioner to get yet a special permit on top of that. Because getting a special permit further defeats, or potentially defeats, the timing associated with eligible facilities requests, which has a 60-day time clock. That being said, to a certain extent, I think this is a procedural difference of opinion between the law department and City of Cambridge and ourselves. We think it's prudent to ask, if the city is asking for us to obtain a special permit, then we would request that that application be reopened, because the city law department feels that under Chapter 48 of the Mass General Laws, this board is only empowered to grant 3 forms of relief: a special permit, a variance, or a reversal of a building inspector's decision. And so those are the only forms of relief they feel that you're empowered to grant, and that you're not empowered, specifically under Chapter 48, to grant an eligible facilities request. In order for you to be empowered to do that, there would have to be a zone change to give you power to do so. And so they feel, the law department feels, that the decision that you granted on 11/19 cannot be codified in a written decision by the law department. And that's been the stumbling block. They feel that that same grant of power for us to make these modifications on this existing wireless installation could be granted by a special permit under the limitations of 6409, which is the way we drafted our special permit. And there have been other petitioners since November 19th who have been before this board who have received relief under 6409, but under the guise of a special permit. And so that's what we're requesting, is essentially to clarify this procedural issue. It was like I could have chosen behind door A or door B, and I chose the wrong door, perhaps.
Well, perhaps, but I think the door you chose was the door that other communities would have had you chosen.
And that,
Cambridge believes its zoning structure is such that the other communities are not appropriate, so their approach is not appropriate for Cambridge.
Sure.
And that's their decision.
Yeah.
So,
And we're here respecting that, and respectfully requesting that that special permit application be reopened, since it was not a final decision in the form of no written decision, and therefore under case law, Dennis v. Manchester, which is a case that comes from the law department, that you are empowered to reopen that matter and revote for that special permit, but in the context of 6409.
is there any discussion on whether we should reopen the case or?
Well, I've no doubt we should open it. I think my own feeling is that if we had been properly advised prior to that hearing that night, we might have proceeded differently than we did. But in the absence of counsel guidance,
I understand that, Mr. Sullivan.
then we were flying blind.
Yeah.
I think we were all flying blind. That's what it is. You were flying
Yeah.
blind and we were flying blind, and that's why we're talking tonight, to see if we can reverse that.
Right. And it was my understanding that you had been advised and that you had been had consultations with the law department. That was clearly not the case.
Clearly not the case.
Right.
I move that we reconsider the decision we reached in November
November 19th, correct.
on this case with regard to the request to withdraw an application for 14 Hour Street under our zoning ordinance. All those in favor of reconsidering?
One question.
Sure.
Was it these 5 members? Or does it
You
have
don't
to
need
be
to
the
make a
same?
difference.
It doesn't make a
No,
difference?
this is not like a case heard. No.
Okay.
Any 5 can do that.
Okay.
All those in favor? Aye. 5 in favor. Okay, so we're reopening the application for a special permit under our zoning ordinance, the standards essentially being that of 6409 of the statute.
Correct.
Now, the portions.
So, Mr. Chairman, members of the board, as I stated on November 19th, this is an application by T-Mobile to modify its existing wireless installation at 14 Arrow Street by adding 3 panel antennas on the existing smokestack, together with 3 remote radio heads. We have worked with both the Harvard Square Advisory Commission, received their consent, in fact, a waiver. It was not required to get a certificate of appropriateness. In addition to that, we worked with the planning board on a number of design changes that really streamlined the placement of these new antennas and made them consistent all throughout. Initially, the antennas were different sizes. We modified that. We made sure that they were as flush mount as possible and they were painted to match. It was their recommendation that we utilize the final design that's before you, and I have a copy of the photosims that were also submitted to the board on
These are
November
the same ones we
18th.
saw back in November.
Yes, they're the same ones that were there the 2 weeks prior to the public hearing on November 19th, and nothing has changed since then. And same thing with the plans that were also
Do you
filed.
have any plans too? or-
Yes, the plans are right here. Yes.
Okay. Thank you.
And so there had been some discussion as to whether or not we would place a stealth enclosure around the top of the smokestack. It was very consistent both from the planning board and the Harvard Square Advisory Commission that we not do that. And it's also our opinion that that would add much too much mass to the top of that smokestack, and I think would detract from the architectural features and potentially degrade the smokestack.
I guess I would point out, and I think I'm right, that what you're proposing tonight is exactly the same thing that we granted you mistakenly, a special permit under 6409 directly in November.
That you granted an eligible facilities
Yeah.
request, that night, correct, and that tonight we're asking for the same design, no design changes,
Yeah.
the same approval. You went through the 6 prongs under 6409 that night. I'm happy to go through them again tonight, but they are consistent.
Why don't you briefly go through them? Just so
I
that
surely can. The 6 prongs is that we are not, number one, that we are not increasing the height of the structure, the base station, by more than 10% or 10 feet. In fact, we're not increasing the height at all of the smokestack. Secondly, that the antennas will not protrude more than 6 feet from the outer edge of the smokestack, and that's clearly not the case, as you can see in the plans. The antennas themselves will protrude no more than 2 feet along from the side of the smokestack. Third, that it will not involve more than 4 equipment cabinets at the site, and the plans clearly indicate that it will not involve more than 4 equipment cabinets. It will involve 3, and they're all inside the building. They're not visible to the public, the equipment cabinets themselves. Fourth, that the modification does not entail any excavation on the ground, and it does not. This is simply installing antennas on the structure itself, no excavation to the structure or to the building, or to the ground. And that fifth, that the modification does not defeat the existing decision for the original decision or the existing concealed or stealth design of the installation. And we feel that consistent with our meetings with the Planning Board and the Harvard Square Advisory Commission, that this is the best design that is consistent with the original design of facade mounting the antennas in the same fashion as the original antennas that are there now. And sixth prong is that the modifications comply with the prior conditions of approval by the zoning board. So we feel we meet all 6 prongs of the eligible facilities request guidelines under section 6409.
Questions from members of the board?
I just have one question,
Sure.
Mr. Sousa. What's going to happen now? Has it changed at all because of your appearance before the zoning boards in the past of putting it up there?
You mean has
Do
our...
you think it's a better design as far as the visibility to the public and consistent with the nature of Cambridge because you came to the zoning board originally? Or do you think it doesn't matter?
So I do know that the design improved from our original filing and our meetings with both the advisory committee and the planning board, that the design did improve. Yes, it did. In fact, it was their request that we make all the antennas conform. We reoriented some of the remote radio heads as well, and we encapsulated them in a stealth enclosure. So I do think that the planning board process and the Harvard Square Advisory Commission process improved it. I'm not taking away credit from the zoning board, but nothing changed with the zoning board. But the process of getting to the zoning board, I think that with respect to this application, it did improve. Yes.
Further questions? I'll open the matter up to public testimony. Is anyone here wishing to be heard on this matter involving 14 Arrow Street? No, apparently no one wishes to be heard. I'm not aware of any correspondence or other communications in our files. So I will close public testimony. Any final comments?
None, Mr. Chairman.
Okay.
I just had
Go ahead.
a board question. What was, so when we approved it on November 19th, what was it advertised as at that time?
It
Was
was
it,
advertised as an application for a special permit under the Spectrum Act that it cited our zoning ordinance, so it implicated our zoning ordinance.
okay,
Although it was clear that the substance of the petition was going to be whether it met 6409 of the Spectrum Act.
okay.
And if I could add to that, Mr. Alexander, Mr. Chairman, you did ask me prior to that last hearing that we modify the notice board to request or to include the fact that we were asking for a special permit or a 6409 eligible facilities request. So both were advertised to the public.
Okay.
Yeah.
But you're saying that the error in our case on the 19th was we were approving it as this, what did you call it, the special?
Yeah, just an
facilities?
eligible facility
Eligible.
request.
We were approving that, which we don't have the authority to
Which the legal
do.
department subsequently told us we don't have the authority to do. And what we do have the authority to do, that is withdrawn, because not knowing that we had to do that. So, errors and all around. Or should we, errors is maybe too strong in my opinion, but
Right.
discussion for another day.
Yes, I agree.
Ready for a vote?
Yep.
Okay, the chair moves that with regard to the special permit being sought, that we make the following findings. That it appears that the requirements of this ordinance cannot or will not be met unless we grant the relief, and we know from the legal department that is the case. That traffic generated or patterns of access or egress resulting from this work will not cause congestion, hazard, or substantial change in established neighborhood character, and that continued operation or development of adjacent uses as permitted in our ordinance will not be adversely affected by what is being proposed by the petitioner, that no nuisance or hazard will be created to the detriment of the health, safety, and welfare of the occupant or the citizens of the city, and that what is being proposed will not impair the integrity of the district or adjoining district or otherwise derogate the intent and purpose of our ordinance. In this regard, as Mr. Sousa has pointed out, what is being proposed has been favorably passed upon by the Harvard Square Advisory Commission and the Planning Board.
Correct.
And that what is being proposed, and I'll get to that in a second, will satisfy the requirements of the Spectrum Act, 6409 of the Spectrum Act. So on the basis of these findings, the chair moves that we adopt the following motion: that the modification to its existing telecommunication facility at 14 Arrow Street proposed by the petitioner does not substantially change the physical dimensions of the existing wireless tower or base station at such facility within the meaning of Section 6409A of the Middle Class Tax Relief and Job Creation Act of 2012, also known as the Spectrum Act. And therefore, the petitioner is entitled to the special permit it is seeking under our zoning ordinance, provided that the petitioner complies with the following conditions. 1, that the work proceed in accordance with the plans submitted by the petitioner and initialed by the chair. These are those plans. 2, that upon completion of the work, the physical appearance and impact of the proposed work will be consistent with the photo simulations submitted by the petitioner and initialed by the chair. It's here. 3, that the petitioner shall at all times maintain the proposed work so that its physical appearance and impact will remain consistent with the photo simulations previously referred to. 4, that should the petitioner cease to maintain or utilize the equipment approved tonight for a continuous period of 6 months or more, it shall remove promptly thereafter such equipment and return the building on which it is located to its prior condition and appearance to the extent reasonably practicable. I believe there should be one more. And 5, that what is being will be erected must match the color of the facade of the building as with regard to the other antenna. That's it. Anybody else have any questions, modifications? All those in favor of granting the special permit on this basis, say aye.
Aye.
5 in favor.
Very good. Thank you,
Thanks,
Mr.
Chairman.
Chairman. Thank you, members of the board. Thanks for your patience on this one.
Yeah.
Appreciate it.
Patience all around.
Yes.